Motion for early termination?
Yes, Your Honor.
All right, and state, are you opposed to the early termination?
The state is not opposed, Your Honor.
Oh, okay,
Always a bonus.
yes,
I have checked in with your probation office and I'll let her speak for herself.
yes.
Judge, I did check in with the CSO and he says that the probationer has been doing great. He feels like he has been rehabilitated. He has not had any compliance issues and he's in support of the early termination.
All righty, so here's the $1,000,000 question. What have you learned?
Not to be causing mischief and corruption, not doing drugs, trying to work better with my record is difficult to get a job. I've been doing temp services and but yeah, being productive citizen, that's what I've learned.
All right, so this is what I'm gonna do. I'm gonna follow your agreement and probation. If you can contact Deanna, they usually have specific places that will hire people who have criminal history. And so make sure you contact them. If you contact them, they'll probably be able to have a job for you probably by the beginning of next month.
Okay.
But here's the thing. I always tell people wanted to be president of the company. You got to start somewhere, right?
Yes, ma'am.
So the key for you is, let me just get a job to support myself, and you can still keep looking for other things.
Would it be possible to get it off of my record?
Oh, you'll have to
Talk
speak
about
to your
that.
attorney about
Okay,
that.
all right.
All right. Good luck to you. Congratulations.
Yes.
Thanks for turning your life around.
Thank you.
I appreciate you. Thank you.
All right. You're welcome.
Thank you, Judge.
Right, thank
Who
you.
else speaks, excuse?
Yes. Well, wait till he gets the information so that we can make sure he has employment.
Yes, ma'am. Thank you very much, Your Honor.
You're welcome.
Pardon me, I didn't know if you were coming. Where are you going?
All right. Who is here on Joseph Grosso?
I am, Your Honor. I have focus.
Yes.
Judge, I conferred briefly with Duffy that we ought to be set for trial next week. Judge, Mr. Grosso is still incompetent to stand trial.
Okay.
We have a status conference. I looked at my calendar in the magistrate court on December 15th, Judge. So it's still out there pending.
All right. So what I can tell you is, depending on what medications they started him on, he may never regain competency. So,
It's likely that might happen. I'll be upfront with the board. Yeah.
so is there any objections then to setting this in late January?
No, Judge.
None from the state.
All right, Ms. Ferguson, if you'll recall this late January, please.
That's fine.
All right, thank you.
Thank you, Judge. Maybe excuse.
Yes.
Thank you.
And Norma, that date needs to be a phantom date because I don't want it to interfere with whatever treatment he's receiving. Thank you. And on what page is Grosso on the docket? Okay. All right, so where is Mr. Saganya?
I'm here, Judge.
Oh, okay, all right, thank you. I'll let you continue. You're welcome. Thank you. All right, who's here on Tiffany Martinez? And after Tiffany Martinez, it will be Baldomero Chapa.
Here, Mr. Chopper, Your Honor.
Oh, that'll be after Miss Martinez. Hello, good morning. One moment. Yeah, counsel.
Thank you, Judge.
You're welcome. And this is your first setting?
No, we've been
No,
here
it's not.
a few
Okay.
times, Judge. We are here in a setting where the state has given a new offer that we'd like 30 days, if the court will give us time to consider this new offer, which is significantly better.
All right, I tell you what, I'll give you 3 weeks because we were actually scheduled for jury trial and the day is for us to obtain a new jury trial date. So really recall that's back in 3 weeks. That will be your final plea deadline date.
Understood, Judge.
All right, Ms. Ferguson,
Yes.
I need a 3-week reset for a plea deadline date, and this is the final plea deadline date.
That's fine.
All right, once you sign the reset form, you are excused. What page is she on? Thank you. Baldomero. All right, so we need a jury trial date.
Yes, ma'am. And Mr. Chapa is here to present himself to this court. He did this court last week. We were vocal with him through that process. He had some car trouble that day. If Your Honor will look at the case file, he has not missed this. We have not had any issues out of
Right,
him.
so here's the thing. He'll need to go in custody. And if you want to call the bondsman.
The bondsman is here and he is willing to remain on the bond, Your
All
Honor.
right, where's the bondsman?
Fernando, you might have just stepped right out.
All right. The document I have from the bondsman is a motion to increase bond.
Mr. Fernando is the bondsman, Your Honor.
All right.
I know him, yes.
Oh, great. I'm familiar with the Birmingham Black Barons from days of old, from history. All right, so with this case, I received a motion for a request for a bond increase. You're no longer requesting that.
No,
All right,
and I have a motion for the reinstated one if I have to,
all right,
but I'm willing to stay on the bond.
all right. So state the court is looking at the docket sheet. He's always been here. Do you have any objection to the bond remaining the same?
We do, Your Honor. He was set for trial and failed to appear at that trial date. And presented a flight risk to this court and to the state, showing the court that when it's time to go to trial, he's not going to be here. And so for that reason, the state would request that he be remanded without bond. And if the court was inclined to set a bond, then the state would ask for 200,000, which would be, I believe, 115,000 more than his original bond.
All right, so we're gonna go on the record and Mr. Roper, I'll note that you have no objection to the bond being reinstated. So let's see what happens with this hearing.
Yes, ma'am.
All right, thank you.
Thank you.
Court is calling 2024 CR 009634. State versus Baldomero Joseph Chapa. Can I have parties announced?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
All right, so state defense hasn't filed a motion for reinstatement of the bond, but the court will note for the record that the bondsman has presented the court with a document asking that bond be reinstated. And it's the court's understanding, state, you're in objection.
We are, Your Honor. The state just would like the court to note that the case was set for trial, and at that trial date, this defendant failed to appear, showing the court that he has no intention of appearing when it's actually set for trial. And so for that reason, the state would request that the defendant be remanded without bond. And if the court is inclined to set a bond amount, the state would recommend 200,000 and full house arrest GPS.
All right, so yes, if you'll address the issue of him not appearing.
Yes, ma'am. It was last week, I believe it was last Wednesday, or it might have been Tuesday, but he did not appear. It was a car issue. He did attempt to come to court on Thursday. I was vocal with him that day. As Your Honor will remember, I believe you were in trial on that day. And your clerk said that Monday morning would be the best opportunity to be able to flesh this out with the short hearing that we're doing now. So that was my suggestion to him, and he did make himself available that day. I have also consistently been speaking to his bonds person who the court has heard from this morning as well. He is going to stay on it. Now, I have not had a problem contacting Mr. Chapa through the tendency of this case, and this is the first time he's ever raised a court date.
So why didn't he appear? I understand the state's argument that it was scheduled for jury trial. So the question is, if he had car problems, then why didn't he still appear later?
We do not have a good answer for that, Your Honor. He missed court, and we can't make him be here for it.
It was a bad game. My steering wheel got like locked. I broke my key trying to unlock it. My phone died. I didn't have no way to charge it. I started walking, trying to get to a phone so I could call my mom. My mom actually had already left to come here, because if not, she would have gave me a ride and I would have been here. It was just one of those horrible things. You know, I've never missed anything when it comes to court, ma'am. I always show up. I'm always proper. I've never had any problem.
And I can tell the court that his mother was here on that court date, Your Honor.
No, I remember his mother was present, but she's not scheduled for trial.
Yes, ma'am.
All right, this is what the court is going to do. The court is noting that the defendant has appeared for every setting besides that specific setting. And he has been scheduled for jury trial more than once, and he's appeared when that jury trial was set. Sometimes there's a lot that happens and it hits somebody all at once, and the court is understanding of that. The court will reinstate the bond. The bondsman has agreed to have the bond reinstated. The court is going to give you all a jury trial date if you'll confer with the state, and that will be your jury trial date. This is what I want to stress to you. And we can go off the record. There are not to be any other things piling on top of each other where you don't make it for court. You have to have backup plans. I understand when a steering wheel gets locked. That has happened to me before, and guess what? It's not unlocking. All right. So he can be released. I'm going to sign the motion to reinstate the bond. Yes, recall the warrant. And bondsman, if you'll give me the documents for the reinstatement of the bond, please. And if you all confer with Ms. Ferguson on a jury trial date for dressing appropriately for court, just have a seat.
Thank you very much, Your Honor.
You're
And
welcome.
once you get that date, maybe you see us.
Oh, you'll have to tell me what the date is.
Yes, ma'am.
Thank you.
Thank you.
All right. Ms. Abrams, this is gonna be September 15th for a PSI. Court is calling 2025 CR 001248, State versus Lynn Morin. Can I have parties announced?
Samantha Lynn Brown for the state.
Louis Martinez on behalf of Mr. Moore.
And are you Mr. Morin?
Yes, yes.
Counsel, have you received all discovery? Did you review that with your client?
Yes, Your Honor. The discovery that I could review with him, I reviewed with him.
Court will find that the state is in compliance with discovery. Mr. Morin, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Morin, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with possession of child pornography with a child younger than 10 years of age. As a first-degree felony, the range of punishment is anywhere from 15 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, Your Honor.
By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Just one moment off the record. Yaya, can you make sure these are file stamped so that the defense can have their motions to seal?
Yes. Yes.
We're back on the record. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Morin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
That's your copy.
Thank you, Your Honor. You're welcome.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to your plea, your punishment is to be assessed at a cap of 30 years in the prison. There's a $5,000 fine. There are no applications in Chapter 62 compliance. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and voted upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
State offers States Exhibit 1 and all attachments and States Exhibit 2 and its contents. And at the same time, I would move for that motion to seal to be signed for the contents of States Exhibit 2, which contains the child pornography images in this case.
That's all without objection, Judge.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Did you understand that there are certain documents that contain child pornography that your attorney and the state have agreed that that would be sealed?
Yes, Your Honor.
And did you understand that in order for it to be unsealed, someone, an attorney or a party, would have to file a motion and have a hearing, and the court will make a ruling on whether or not to unseal that?
Yes, Your Honor.
So after today, do you understand that that document or those documents will be sealed, and those documents will not be accessible to the court or to the state or to the defense or to you? Do you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. This will be set for sentencing on September 15th. Once you sign the reset form, you will be excused, and if you'll talk with probation, they will do what's called a PSI investigation. It's not for purposes of probation. It is merely for me to obtain more information about you. Do you understand? All right, thank you.
And Judge, just
Yes.
really quick, did you admit State's Exhibit 2 as well, which is the seal?
Yes.
Okay, perfect. Just want to make
Thank
sure.
you.
Thank you, Judge.
All right, thank you. No, just a PSI.
Thank you, Judge. May I have your excuse?
Yes.
All right, let's talk about that. We had a stacked courtroom calendar under Judge Boyd, and this hearing offered a good mix of efficiency, compassion, and a few moments where the gears of justice needed a little WD-40. Judge Boyd ran a tight ship, is always professional, fair, and sharp as ever, especially when juggling a flurry of bond reinstatement motions and plea negotiations. One standout was the early termination motion, where the judge's demeanor balanced warmth with pragmatism. The defendant, who had a solid report from probation, gave a halting but earnest answer about what he'd learned, mentioning being a productive citizen, though with a bit of comedic timing that only courtroom nerves can produce. Judge Boyd's advice on job hunting was delivered with real-world wisdom and a touch of mentorship, which is always refreshing to see from the bench. Things took a more complicated turn with the Baldomero Chapa case. He missed a trial date due to what sounded like an automotive catastrophe, a locked steering wheel, broken key, dead phone, and a bit of miscommunication all stacking up. His attorney was honest that they didn't have a great answer for why. He didn't eventually show, but they did present a picture of someone generally compliant throughout the case. The state was understandably skeptical, pushing for a significant bond increase and full house arrest, citing Chapa's no-show as evidence of flight risk. Judge Boyd acknowledged the seriousness of missing a trial setting, but also weighed the defendant's overall record and the bondsman's willingness to stay on. In the end, she reinstated the bond while laying down a clear warning: no more mishaps and definitely no excuses. Her analogy about the steering wheel locking, that sweet spot of personal anecdote and judicial authority. You could tell this wasn't her first rodeo. And then we had the Lynn Morin plea handled with methodical precision. The defendant understood the charges, acknowledged his rights, and entered a guilty plea with the appropriate waivers. The court was careful to explain everything, especially the sealing of evidence, and ensured all parties were clear and in agreement. Morin's demeanor was respectful and cooperative, and his attorney was professional and thorough. The whole exchange was a textbook example of courtroom protocol. Overall, the atmosphere stayed businesslike with some moments of levity. Judge Boyd even cracked a brief smile when speaking about baseball teams, showing how a judge can keep control of the courtroom while still making it human. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.